Hello, everyone, and good evening. So, welcome to week 3 of our LAWS 11065 unit. And tonight we will be discussing the topic on the Parliament, the role of the upper house in a parliamentary democracy. And of course, we will be talking as well of the role of the lower house. Now, this topic is probably of major relevance at this time, especially because, as you have noticed, two of Australia's senators, they would be Senator Ludlam and Senator Larissa Waters of Queensland, were forced to resign from the Parliament as a result of holding a dual citizenship. So I think in the case of Senator Larissa Waters, she also is a citizen of Canada as well as of Australia. And there is another senator, also from Queensland, Senator Matt Canavan, who is currently considering legal action to actually test whether or not he is qualified to continue in office as a senator of Australia, mainly because, as it turns out, he also is a citizen of Italy, although, as he claims, it wasn't through any action on his part, but mainly through the actions of his parents, or both of Italian descent and citizenship, if I'm not mistaken. And so therefore, I think I've seen some comments as well in the chat box. We're beginning to appreciate the value of constitutional law. The interesting thing, though, is that amidst the current controversy about some senators as well as members of the lower house whose allegiance may actually be questioned on the basis of Section 44, because they happen to be a citizen, for example, of a foreign power, and therefore, in that case, may have an acknowledgement of allegiance or obedience or adherence to a foreign power. What seems to be forgotten is that Section 44 also provides, and I'm going to read it now, is that any person who is a subject or a citizen or entitled to the rights or privileges of a subject or citizen of a foreign power is also disqualified from being a candidate for federal parliament. So it is not just a question of somebody who is a senator, somebody, and I'll read it again, who is entitled to the rights or privileges of a subject or citizen of a foreign power is also disqualified from running for federal parliament. Which means, for example, somebody who might be a resident of New Zealand, a permanent resident of New Zealand, or who might be a green card holder in the US, arguably, because these persons are entitled to certain rights or privileges of a subject or citizen of a foreign power, are arguably also disqualified from seeking office in the federal parliament. And that is something that hasn't been tested. And I'm actually considering writing an opinion piece on it in the conversation, because that seems to have been forgotten in this debate, in the wider debate about whether or not certain senators or members of the lower house happen to be citizens of a foreign country. And so as we move on through our unit, and because we're in week 3 now, you will begin to see the relevance and the importance of constitutional law. And I think you will probably agree with me that it becomes a major advantage to you. Okay, hang on. It's my dog outside. Could you just give me a second? I need to bring my dog in because it has been barking. Oh, sorry, my video was actually off. Give me a second. I'm just gonna grab my dog. Okay, I couldn't find my dog. It's gonna bark again later. Okay, so yeah, so as we move on, you begin to appreciate the importance of constitutional law. Where is my dog? Hang on. Oh, I think it might be in my bedroom. Give me a second. Hold on. Sorry about that. Sometimes it's easier to just kind of rein in and control. My younger daughter is actually 6, but with dogs, you know, they can bark at very unlikely moments. So apologies for that. Okay, so having provided a background as to the importance of constitutional law, and in particular, the importance of knowing more about the Parliament, I wonder if there might be any questions that you might want to raise at this point about any of the previous topics that we have covered in our unit, as well as any questions that you might have in relation to any of the assessments. Would there be any questions? Because otherwise, we will proceed to go over the 5 tutorial questions that we have for tonight, and which are actually posted in Moodle as well.
I have a quick question, Manjo, just in relation to the assignment.
Yep.
You sent out that Excel spreadsheet today, and I noticed that my name, along with some of the other group members' names, comes up in multiple groups. We did send you an email in regards to that. Some of us had already had groups established since week 1, and you've actually separated us and put us into different groups, and we're now showing in 2 or 3 groups. Yeah. And we're getting emails from all these people that are not within our group. So
okay, I think of an explanation for that. What had happened was that a number of students actually sent out emails early on in the unit about groups that they had formed, but then subsequently sent an email asking everyone, including those who had already formed groups, to actually put their names in the MS Excel file that had been posted online. And it is possible, Nicholas, that some of you may actually have failed to update that MS Excel file. And I based the groupings initially on the MS Excel file of those who actually formed groups. And so those students whose names did not appear to have been part of groups were then randomly assigned to another group. So I think that could have been what had happened. Now, oh yeah, go ahead.
I was going to say, yeah, no, I did go through and fill in the Excel file and updated it. I put in first name, last name, and student ID of everyone. And I think we were group 15. We were one of the first in the door.
Okay. If it's all right, can you just send me the email and I will sort it out?
Yeah, email's already said.
Okay, thank you. I'll respond to you as soon as I'm able to go through it after tonight's tutorial. Thanks for raising that with me in the class. Thank you. Anyone else? So we're good. Okay. So I'm glad to hear from Monique that things seem to be coming a little clearer each week. Yeah, because at the start, a lot of these constitutional law concepts seem to be a bit disjointed, and you don't know how they actually link to each other. But as you move along, you will notice that there are certain constitutional law principles that kind of actually flow through anything that happens. And one of those mainly would relate to the issue of separation of powers. And then the other one would be the balance or the tension in relation to the powers of the federal government and then the state governments. So those are the two key concepts or topics that usually cut across any constitutional law issues that crop up. Okay, so proceeding with tonight's tutorial, after this session, in terms of key outcomes, you should be able to discuss and explain responsible government. Why is it the responsible government? Oh, okay, yeah. In the context of the Australian Commonwealth and the representative principle in Australian constitutionalism. Okay, so let's begin. Yeah, see a message here from Kathleen. Okay, she's also experiencing problems with the Excel spreadsheet. I'm just gonna ignore for now the chat because otherwise I get confused, but I will certainly go back to the chats in a short while. Okay, so discussion 1. Under the principle of responsible government, the Governor General acts on the advice of the Prime Minister. By what legal authority would the Governor General have to dismiss a Prime Minister who refuses to tender the resignation of his ministry? And this particular question would be relevant, especially given the fact that in Australia's history, we've had a case of Prime Minister Gough Whitlam, who was dismissed by Sir John Kerr, who was then the Governor General around 1974. And so we begin to wonder, what would the basis be for the legal authority of the Governor General to dismiss a Prime Minister who refuses to tender?
Federal government appropriations bill for money to run the government.
Okay, go on, Nicholas. Can you...
Well, it's pretty clear. I went through it and I read it. If the government puts forward a proposal for appropriations and the Senate knocks it back, so the upper house knocks it back, then there are a couple of things the Governor General can do. He might decide to either dismiss the government, but that depends on the time frame that's left. If it's within, I think it's within a 6 months time frame of some appropriations, he would decide to let the government carry on. He may institute a situation where he puts a tentative government in place, and during that time, no bills or executions on government is made. It's just basically a process of keeping the ship running, so to speak. The other alternative is if they can't get something completed, then he might call for both houses, the Senate, to come together and decide on what they're going to do. And then if that doesn't happen, then he has the possibility to finally dissolve the government and go to an election.
So in that case, we're speaking of an instance where there might be a deadlock between the lower house or the House of Representatives and the Senate.
Correct.
In relation to a proposed law.
Correct.
So, very good. That's specifically according to Section 57 of the Australian Commonwealth Constitution. Now, what if there really isn't a deadlock? In other words, Section 57 is not something that can be invoked because it doesn't really apply. And yet, in other words, as pointed out here by Jamie, no, not Jamie, but from Leone, what if it's a such situation where the Prime Minister might have lost the confidence of the House of Representatives? And in that particular case, what if the Prime Minister refuses to tender the resignation of his ministry?
I'll have a go at answering. Is it by convention? Because Section 64 of the Constitution provides power to appoint officers to administer the departments of the government, but it's silent on termination. And so by convention, the Governor-General would have the authority.
Very good. So that's correct. So because you cited Section 64, there is actually a constitutional basis for the power of the Governor-General to dismiss. So that is not by convention. You're right. Section 64 explicitly provides that the Governor-General has the power to appoint officers who may then appoint the officers to administer such departments of the state of the Commonwealth. And usually the power to appoint carries with it the corollary power to remove. It's implied in it. So that is a constitutional basis. You're right. There is a second aspect, and somebody raised it, I think. So thank you, Monique. You're correct. So what we're doing now is looking for all the legal authority or the legal basis by which the Governor-General may actually dismiss a Prime Minister refuses to tender the resignation of his ministry. So we have Section 64. Anyone else? I think somebody talked about the reserved powers. Who was that? Job? Is that Job? Job said something in the chat box about the reserve power. Would you care to take the mic, Job? Or is that Joby? I'm not sure. How do you pronounce that?
I think it was Marcus, wasn't it?
It's Joby to everyone that I'm seeing here. Is there anyone there? Unless Job has a problem with the mic. Can somebody take the cudgels? The mic may not be working. That's right. So can somebody take the cudgels in behalf of Job to talk about the reserved powers? Anyone? What do you think? Okay, so if you will notice, Section 61 of the Australian Constitution also provides that the executive power is vested in the Queen, and that the executive power, which is vested in the Queen, is exercisable by the Governor General for the purpose of the execution and maintenance of the Constitution, as well as the laws of the Commonwealth. Again, that is a recognition of certain powers that are reserved in the Governor General.
Is that 61 on its own, Manjo, or is that 61C?
That's Section 61, because there's only one paragraph in Section 61.
Okay.
So that's the second one. Monique actually talked about the convention earlier. So by convention as well. But convention is distinct from a constitutional provision, because by convention it means that even in the absence of any explicit or even implied authority from the written constitution, by practice, political practice or constitutional practice, so like in the UK, there is no written constitution there, but by continuous practice in the UK Parliament, for example, there is a practice that when a Prime Minister refuses to tender the resignation of the ministry, it is possible for the Queen of the United Kingdom to actually dismiss a Prime Minister. So that is a political practice that is almost equivalent to a law. So therefore, we have three legal bases by which the Governor General may dismiss a Prime Minister: Section 64 of the Australian Commonwealth Constitution. Secondly, it is on the basis of what may be known as a reserved power, as duly recognized by Section 61. And then by convention, the Governor General has the power to dismiss a Prime Minister. And again, this is important because we've had the event in the history of Australia where Sir John Kerr dismissed former Prime Minister Gough Whitlam as Prime Minister of Australia. And he invoked, in consultation with Justice Anthony Mason then, these three legal bases for the dismissal of a Prime Minister. But then that raises the question of the extent to which a Governor General who is actually unelected, who is actually appointed to the position, to dismiss a Prime Minister who is actually duly elected by the House of Representatives, which actually carries the mandate of the people. So there's the tension there. To what extent should the Governor General, who is in an appointive position, be permitted to dismiss on his own the Prime Minister who carries the mandate of the people? And in fact, the exercise of that power by the Governor General really brought in this question of whether or not we should become a republic that should then be free from any political influence, even any historical remnant of the UK parliamentary system, and just become a republic so that you can't have a single person who is even in an appointive position to actually dismiss a Prime Minister. So that has happened in the past. But at the same time, it was a very important historical moment because it then made the members of the House of Representatives and the Senate realize that, you know, if you have a constitutional crisis such as this, it can really be destabilizing to the entire nation and very costly. So there is that tension about the question of representative democracy on the one hand, and the existence of certain conventions as well as constitutional provisions, which are not often used, but when used, can have very huge political and legal implications. Okay, so moving on, we go to question 2. Ratapalo and Crow in their book said that it is an ancient common law of constitutionalism that courts do not interfere in the internal processes of Parliament. What does this practice of non-interference mean? Because, you know, you can again raise that question about whether or not Senator Canavan or Senator Ludlam or Senator Waters have to resign from the Senate, can it be said that that question about their citizenship and whether or not they can continue to be in office is actually an internal process that can be solved by the Senate, for example, passing a resolution or even passing a law providing that, if a person or a senator happens to have a dual allegiance, but it was unintentional, then on that basis, that will not amount to a violation of Section 44 of the Australian Constitution. So did you see that example that I gave? So the question is, what do they mean by Ratnapala and Crow? What do they mean when they say that it is an ancient common law of constitutionalism, that courts do not interfere in the internal processes of Parliament? What does this practice of non-interference mean?
Isn't just a common law way of saying there's a separation of powers, Benja?
Okay, go on. So what does it mean? Go on. So how does that apply?
It means that the judiciary won't discuss or even consider making rules. They're only there to enforce them.
Okay. So if you have a situation that I gave earlier where the Senate may pass a law, they may pass a resolution, they may even pass a law, it becomes a law because the House of Representatives agrees with a bill pertaining, for example, to a definition of what constitutes dual allegiance according to Section 44. In that case, the question might be whether or not courts will be interfering with the internal processes of the Parliament when the Parliament itself defines what Section 44 means. And so related to the question is, what does this practice of non-interference mean?
But if they were to do that, does that not just mean they're bypassing the Constitution in sort of plain English terms? They're just finding a way around it. I mean, that was the fundamental law that the Constitution or the Commonwealth came into power with. It's and they're just trying to circumnavigate it, really.
Okay, what do the others think?
Well, I think they could possibly make the change, but they'd have to take it to referendum first based on the Constitution. I mean, if they wanted to make the change to make dual citizenship okay, then they could legislate it, but only after they went to referendum on that question first and the Australian public voted to change that within the context of the Constitution as it stands.
Okay, I see a long comment here from Kathleen. So I'm not able to read that, Kathleen, in a short while. If you could pick up the mic in a short while and discuss it. Now, the point that I'd like to raise, though, is that if you examine a lot of statutes that have been passed by the Parliament, those statutes often contain a definition of the terms that they're using in a particular statute. And the point really is that, is it really a question of amending the Constitution when the Parliament seeks to define what citizenship might be or dual allegiance might be? After all, it is one of the powers of under Section 51 of the Australian Commonwealth Constitution that the Parliament has the power in respect of issues of citizenship.
I think basically the judiciary is not going to interfere with what Parliament does until such time it is a law, and then it's brought before the High Court to determine its validity.
Very good. So who was that? Who said that?
Erin.
Erin. Okay, thank you, Erin. Rin. Okay, thank you. Oh, so that's Rin Thomason? Did I get your last name right?
Yes, that's right.
Okay, thank you, Rin. So that's going to be crucial to the point about non-interference in a short while. But let's make the assumption that the law has been passed, and in that case, somebody actually brings the question before the High Court. So, or it could be before the Federal Court of Australia. And the question really is, at that point, what is the likelihood that the Federal Court or the High Court will actually intervene and determine whether or not the law passed by the parliament is actually constitutional or not? Or would the act of the federal court or the high court in trying to determine the constitutionality of that law not impinge on the internal processes of parliament in determining what might be the appropriate qualifications of members of the parliament?
Isn't the onus on the person that brings it to court to prove that it's a breach of the Constitution? It's not the judge's decision to decide that. The person who brings it to court has to prove.
That's right. So let's assume that has been done. The question really is, would it violate, for example, the separation of powers for the federal court to rule on the constitutionality about the qualifications of the members of the parliament? Or is that not an internal process of the parliament? Which means
I think the High Court Manjo has that right. That's what it's there for. And as such, it's not interfering with the internal process of government because it's already gone through those internal processes and has been brought into law. So therefore, the High Court is only doing its job and testing that law against what the Constitution says.
Very good. So as Rin correctly pointed out, in that particular case, it is the duty of the courts under Chapter 3 to actually determine or review the constitutionality of such a law. It has nothing to do with interfering in the internal processes of Parliament. What that then, Rin, because you mentioned this earlier, what do we mean by the practice of non-interference then in the processes of Parliament? What does this refer to?
I guess before any law has to find its way to get the approval of the Governor-General, it goes through both houses and it's debated back and forwards and things like that. And those are the internal processes that take place before it's finally determined, when they finally determine, well, what is the law going to say? And then that goes to the Governor-General for stamping. And then once that happens, that's all the internal processes are out of the way. If somebody doesn't like the law and they can think they have a ground to challenge it, that's when the High Court will come in and determine that.
Very good. Now, but what if it's clear to a senator or a member of the House of Representatives or even an ordinary citizen that a bill that is being proposed and being debated in the Parliament is obviously unconstitutional, because it would probably require a constitutional amendment to pass that bill into law, or it is on a field where the House, the Parliament does not have the competence to legislate on. The question is, wouldn't it be possible then for a member of the Parliament or the public even to bring a question of constitutionality before the courts?
Doesn't it have to become law before anyone else can interfere?
Very good. So that's right, Angelina. So in the case of Cormack versus Co., the High Court was clear that it will not interfere in the internal processes of a parliament for as long as a bill is still being debated. It has not become law because it hasn't been given to the Governor-General for his assent. It will be a form of interference for the courts to try to intervene and stop the passage of such a law until such time that the bill has not become a law because it hasn't received the Governor-General's assent. The courts will not interfere because that is an internal process of the Parliament. Okay. Questions so far? Now let's look at a comment. I'm unable to go through the long comment of Kathleen, but she has another comment here. Courts, however, can only identify such legal issues once the legislation has been passed and upon being approached by a person has been first affected by the legislation's alleged constitutionality. Okay, very good. From Chris Smith, he said that courts don't rule on, or a court doesn't rule on hypothetical situations. And that is correct, because if you will notice, if you look at Section 75 of the Australian Commonwealth Constitution, it does provide that the original jurisdiction of the High Court is in relation to matters. And matters has been defined as instances where there is an actual controversy between parties. So if it is a hypothetical situation, and in that case, if it's just a bill, there is really no actual controversy because no one is affected by a bill. It hasn't become a law yet. It has no effect. It cannot even be executed. So in that case, that again is a situation where it becomes hypothetical. It is premature for such an issue to be brought before the court. So that would be the second reason that decided. Who was that? Yes, Nicholas.
Manjo, can you just explain a little bit more about standing in that context? Because to be able to take it to the High Court and challenge it on a constitutional basis, you have to have a particular standing. Does that mean that anybody that is potentially affected negatively by that action, once it becomes law, has standing, or is there a limitation on standing?
So just to be clear, we're speaking here of a law. In other words, it is a bill that has become law because it has received the government.
Yeah, it's already law. It's been assented by the Governor General. It has a time and a date for enactment.
Yes. So it should be clear that not everyone will have legal standing. It is crucial.
Ninja, this gets back. Can I just interrupt? That sort of question gets back to those bikie laws that were brought into Queensland. One of the gang members actually challenged it, and they said, "Well, hang on, you don't have the right because you haven't committed an offence against that particular act. Therefore, you can't challenge the law."
That's right. So let's be clear that not every law that is passed actually affects everyone. So, for example, that if there is a law that might relate to the building of roads, it is possible that that will not affect certain people in a particular area, so they won't have any standing. So it is still crucial that even if a law has been passed, anyone who seeks to challenge the constitutionality or the validity of a law is able to establish his or her own legal standing. So legal standing would still be necessary.
So the clarification of that is legal standing is they have to be negatively affected by that law in that instance, because you could have some people that could be affected by that law, but not necessarily negatively at that point, like with those bikie rules.
That's right. So there is really no reason why, in terms of legal standing, it has to be understood in terms of negatively affected. The question really is that whether or not a particular legislation has affected. There is no requirement that the effect has to be negative or positive. So anyone whose rights, interests, or legitimate expectations have been affected by a legislation have the legal standing to question the legality or constitutionality of a law.
Wouldn't it be a rarity, though, if somebody actually contested a law based on the premise that it actually affected them in a positive way? I mean, I can hear what you're saying. They have the option to do that, but would they do that?
That would be quite unlikely. But again, what we need to remember is that there are certain individuals who might just be interested in really ensuring that constitutional processes are followed. And so somebody, for example, who hasn't really been affected negatively by a law may question the constitutionality of a law from the viewpoint of whether or not the law meets the standards of constitutional law. So in that case, it's difficult to say that there has been a negative effect on a person. So there are individuals, for example, whose goal is to make sure that anything that is passed is really above board and according to constitutional law processes. So there is no requirement that a person can only have standing if there is an impairment of his or her rights. There is no requirement. The important thing is that the law has an effect. Okay.
Margaret, can I just ask a question in regards to that?
Yes.
So on page 29 of the textbook, there was the case of the Australian Conservation Foundation versus Commonwealth.
Yes.
Now, a minister had approved a development project, but had done that before the environmental impact statement, and the courts ruled that he had no standing. So in that situation, were his rights not impinged on because obviously they didn't do due process, or am I not on the same wavelength as what obviously the High Court had done? Because I thought if they hadn't gone through due process and he just made a decision based on his own office, doesn't that affect the public?
Yeah.
Or the people?
Yes.
So I was confused about that.
That's right. So in general, when we speak of legal standing, it cannot be legal standing that affects everyone in general. Legal standing talks about the effect specific to a person or group of persons. So that is the general rule. So in that case, the foundation, for example, if it claims a broader interest in being affected by a legislation or government policy, but it cannot identify a specific effect on itself, then you have a problem concerning legal standing. Okay, but having said that, as I pointed out, you do have situations in relation to the question of Nicholas, where there might be certain individuals whose intention really is to look at the constitutionality of certain legislation. And for example, it could be an association of law professors whose main goal is to ensure that any legislation that is passed is actually something that is in conformity with the requirements of the Constitution. So it is possible for them, for example, it doesn't mean that the court will agree to that, but then it is possible for the High Court to consider that in that instance, they may have legal standing. But again, in that case, that remains to be seen whether or not a federal court will actually consider a legal standing in that case. But I was responding to the broader question of Nicholas, whether or not there was a requirement of a negative effect of a legislation before somebody can be considered to have legal standing. Because as I said, there is no requirement that the effect has to be negative. It can even be a positive effect. Okay, so we have a comment here from Gordon. In Coleman versus Power, a man contravened the Queensland Vagrants Act of 1850, which offended the Constitution. He then had legal standing. Yep. So you will have situations where a person has not yet really been affected by a piece of legislation, but potentially can be affected by the effect of a legislation. And in that particular case, it can be said that a person's rights or even legitimate expectations or interests can potentially be affected by a piece of legislation. And therefore, that will be the basis to argue that that person has a legal standing to file an action in court questioning the constitutionality of a law. Okay, so we can move on to question 3. This should be quick, hopefully. In Cormack versus Cope, Justice Menzies said, the courts will not interfere with the proceedings of Parliament or the Houses of Parliament. Why are courts disinclined to interfere with the proceedings of Parliament?
That was basically been answered, I think, Manjo, hasn't it?
Yep, go on. Can we just...
Separation of powers, isn't it? It's as clear cut as anything.
Very good. Okay. I knew that was quick. Thanks. Okay. Can somebody answer discussion question number 4? Can somebody read for us discussion question number 4?
Okay, I'll do it. After the federal elections on 7 September 2013, it was discovered that because of computer error, the populations of some states were overreported, while those of others were underreported. Had the correct populations been reported, the entitlement of states in the House of Representatives would have been different. For example, Queensland and New South Wales would have had 32 seats, not 30, and 50, not 48, respectively. On the other hand, Western Australia would have had only 12, not 15 members. Claiming a systematic failure of elections, 3 members of Parliament filed suit in the High Court to invalidate the 2013 elections. Rule on the action.
Okay. What do you think?
I said that it would be a valid action under Section 24 of the Constitution, because Section 24 requires that the number of representatives of each state must be in proportion to the respective numbers of their people.
Okay. Very good. Who was that? Monique.
Monique, sorry.
Yes. So that's, thank you, Monique. That was section 24. How about the claim that there was a systematic failure of elections? Because if you'll notice in the facts that I gave, Queensland and New South Wales would have had 32 seats, not 30, and 50, not 48 respectively. What do you think about that?
Would they be challenging the outcome of the election, or would they be challenging the administrative aspect of it behind, you know, the getting the populations right and everything before the election?
Mm-hmm. So it's actually what they're alleging in the scenario. Thank you, John, for the question, for clarifying that. What they're attempting to do is really to say that there has been a systematic failure of elections, at least in relation to Queensland and New South Wales. So they're essentially saying that the elections in those areas should be invalidated because of the fact that, you know, Queensland, which ought to have had 32 seats, only got 30 seats during the electoral exercise, and New South Wales had 50 when there should only have been 48. So in other words, if we follow the system of proportional representation, there should have been other states which should have had more representatives elected in their states. So there is a claim of systematic failure of elections, and they're attempting to file suit in the High Court to invalidate the 2013 elections, therefore. What do you think?
Couldn't there be a deviation of 1/10 though on either side under S24?
Mm-hmm. Okay. Okay, go on. So how do you think might the High Court rule on the action?
I would rule that it was valid because under S24 it can be out by 1/10.
That's right. So very good. So in all likelihood, the High Court will still uphold the validity of the elections, mainly because of that leeway of 1/10. But more importantly, what is crucial actually in the elections is the fact that the representatives have been directly chosen by the people of the Commonwealth. And if you will notice still, despite the fact that there may have been issues about the number, the fact remains that despite the computer error, the number of members of the House of Representatives, the crucial requirement is that the number of senators, for example, has not really been affected, because the number of senators would remain the same, notwithstanding this small number, which appears to be problematic.
Manjo, if you read that though, where it says, on the other hand, Western Australia would have had only 12, not 15. That's more than your 10%.
That's right. So, but again, that brings into that question, arguably, that the High Court might feel that it will be up to the Parliament as a co-equal branch of government to decide on that as a political question, because it can be said that at the end of the day, it is actually the Parliament that can determine the correct number of representatives that should be elected into office according to each electorate or each state. So there is that argument that could be made that this might be an instance when the High Court may consider that, one, it is a political question, and two, that there is that leeway that can be given in terms of interpreting the number of representatives that there should be in the House of Representatives, and that thirdly, there hasn't really been much of an effect in terms of representative democracy, mainly because it can be argued that the question of the direct election of the members of the House of Representatives has not really been impaired, because the members of the House of Representatives were still elected by the electorate of both of Queensland and New South Wales. So sometimes what is crucial to realize is that answers are often not clear-cut. So even if you were given a test such as this, it can actually go either way, because in particular, if there is no existing court case that has resolved that particular issue. So what we need to realize is that given certain theoretical scenarios where there is no particular case law that is able to resolve a factual or a theoretical scenario, it is possible for a student or somebody to argue either way. And that's really the purpose of why we have lawyers, and you have different lawyers arguing different sides. And at the end of the day, it will be the high court or the court that will be making a decision. What is crucial, though, in the process is for a student or for a lawyer to be able to identify what the legal issues are involved in the factual or theoretical scenario, and then to be able to cite the law, and then use the law to argue on the basis of the facts that his or her position is actually the one that should be accepted with the court as the correct law on the matter. So that an argument can be made, unless it's very clear that on the basis of the case facts, it has been something that has been decided by the High Court. So I've had, for example, discussions with Michael Nancaro, and to him, in many of the theoretical scenarios, it is really difficult to say that this is the only answer that should be given, and I accept that. So what is important, however, is for you to be able to make an argument. You should be able to identify the legal issue. If you've succeeded in doing that, the next question is, have you stated the correct law? If you've done that, it is now a question of trying to make an argument in saying that on the basis of the law and its application to the facts, this is the conclusion that should necessarily arise.
So you're talking about the IRAC principle, right, Manjo?
Yes, I'm talking about the IRAC principle. Yes, I am. Yes, thank you for pointing that out. So, because remember, what we're doing here in the process is actually trying to get more familiar with going through the IRAC process and trying to formulate an answer to legal problems. So it just becomes easier, because the problem really is that if you're given a legal-based scenario, if a legal problem, before you can even state the conclusion, or before you can even state the law, you really have to begin with identifying the legal issue, because the legal issue determines what the law that you need to cite. You cannot state the law without knowing what the legal issue is, because if you just state the law, it may be a law, that's right, it may be a legal principle, but it has no relevance to the scenario. So it's crucial that given a set of facts or a hypothetical scenario, what is really the legal issue that it raises? And once you've done that, only then should you be able to identify what the law that potentially can apply. Okay, so let's move on to question number 5. Can somebody read question 5 for us?
Manjo, before we go on to question 5, can you just check the chat? Gordon's asked a fairly interesting question there.
Yes.
He asked, is there a process whereby the Parliament can determine what the electoral boundaries, I presume he means what they are?
Yes, so there's nothing in the Constitution which actually provides for the exact process by which electorates can be determined. That is actually left to the House of Representatives or to the Parliament to determine. So if, for example, what can happen is that there is an attempt to gerrymander. In other words, gerrymandering would be an instance when political electorates are actually done on the basis to favor a certain political party or a particular candidate, so that sometimes the political delineations become absurd. So in that case, again, that is likely to be a political question. It is unlikely for, unless, because this particular question has sometimes cropped up in the United States Supreme Court as well. And unless as far as the United States Supreme Court has said in certain cases, unless the instances of gerrymandering is particularly evident in the sense that it is really meant to favor a particular candidate or a particular political party so that it becomes an affront to representative democracy. If it were just a clear-cut question of gerrymandering, it's difficult to say that gerrymandering was done for the purpose of eluding the will of the people, or of trying to suppress the will of the people. That's difficult to claim. So in general, it becomes up to the parliament, for example, to determine how electorates should be formed.
Does that matter whether it's state or federal elections, though? Because my understanding was the states determine those boundaries, but does that also include for federal elections?
Rin, at this point, I'm not really sure how to answer that question. I have to be honest. So it's something that I need to look up, because that's quite detailed into the process of elections. So that is something I have to examine, because there's actually typically a separate subject for that, which is about election law. And in general, I focus on the bigger constitutional law questions. So I'd have to defer giving you an answer in relation to that particular question. But I could look it up for you.
Thank you.
Thanks. Okay, now, question 5. Can somebody read question 5 for us?
The Parliament passed a law that whenever a vacancy happens in the House of Representatives within 9 months prior to a general election for the House of Representatives, a Member of Parliament may be appointed by the Governor-General on advice of the Prime Minister to fill that vacancy. Rule on the validity of such a law.
Okay. Comments on the others? Anyone would wish to provide an answer to that question?
I'll have a go. It's Monique. I said, by virtue of Section 64 of the Constitution, the Governor-General has the power to appoint officers to administer departments of government and form part of the federal executive. However, such appointment is limited to a period of 3 months unless he is or becomes a senator or a member of the House of Representatives. And therefore, I said the law would be in breach of Section 64 due to the appointment period of 9 months, exceeding that which is specified to be the extent of the Governor-General's power.
Okay. Other
isn't that with respect to the ministers, not the House of Representatives? So I assume from that the Governor-General could appoint someone from the House of Representatives to the ministry, but he couldn't necessarily appoint just anyone to the House of Representatives, because that would not be according to the House of Representatives being elected rather than being appointed. Do I have a point there?
That's right. So I'm inclined to agree with thanks, Monique, for raising that point, and thanks, Gordon. I would be inclined to agree with Gordon, because if you examine the express language of Section 24, it provides that members of the House of Representatives are directly to be elected directly chosen by the people of the Commonwealth. So in that case, therefore, it would be a clear contravention of Section 24 of the Constitution for the Governor-General to exercise the power of appointing somebody to the House of Representatives. There's the requirement of a member of the House of Representatives, and even of the Senate, to be directly chosen by the people, either of the Commonwealth or of the states, in the case of the members of the Senate. Okay, we go to final question 6. Can somebody...
So what happens then if say, a House of Representatives member dies or whatever? Who do you say then replaces that person in the House of Reps?
No one does.
Or are they indeed needing to be replaced?
There is no requirement that they need to be replaced. No one replaces that person unless a by-election is called for the purpose of replacing the person. So no, there can be no temporary appointment of a member of the parliament because of the disability or death or incapacity of a certain person, or the resignation of a member of the parliament. Because a member of the parliament can only be directly chosen by the people.
So what happens in that case then if the executive at that time is only in power, let's say by one representative, and that representative dies, and then who has the power in the House then? Are we back to saying that we've got to go to a general election because neither side of the House has more authority than the other anymore? Or do we just continue on as normal?
So the key point there is that that status quo will continue. In other words, that vacancy will remain unfilled unless a law is actually passed calling for an election. So there will have to be an election.
Yeah, there'd have to be, wouldn't there? Because otherwise that could cause a bit of drama with trying to get any bills through the House and then through the Senate, because there might be a little bit, there might be sort of a situation where nothing is going to happen. We might end up being forced to have the Governor-General say, right, out you go, and in come another government.
That's right.
In that situation, a by-election would be held to fill that vacancy as soon as possible.
Yeah.
I don't think, I mean, that would be authorised under the electoral commissions.
That's right. Potentially, that can be done. Yeah.
So what's going to happen with these senators, the Greens senators, and with Bob Day stepping down? Would that call a by-election as well for the Senate, or
yeah, some of these questions actually delve really on election law. And honestly, I'm not prepared to answer specific questions about election law, and neither will it be tested on the nuances of election law. So the focus of constitutional law is to just discuss the broad outlines of the Constitution pertaining to the powers of the Parliament and even in relation to elections. But the details, these will have to be taken up in a course such as on election law, Gordon. So I'll have to admit my limitation in relation to election law because I'm not in a position to answer that.
Okay, Manjo, we'll accept your reason as long as you accept ours that we're only amateurs in constitutional law.
Constitutional law is different from election law. Election law is, it's really a special area of law, and it's not really part of the discussion on constitutional law, except for the broad principles. Okay, we've got 2 minutes to go. I understand there'll be others who will have classes after this. Can somebody discuss question 6 for us? But I will certainly review the questions that have been raised in relation to election law, and I will get back to you on that. Because this is the first time that I've been confronted with specific questions on election law, and unfortunately, it is not an area that I teach. Although it does affect, it is in a sense related to constitutional law. Can somebody read the final question for us? We've only got 1 minute to go.
Yep, okay.
Yes,
a 17-year-old Australian citizen joined the Australian Defence Force, arguing that if he is old enough to die for his country, he should be old enough to vote. He sought enrolment to vote with the Australian Electoral Commission, the AEC, for the 2014 special election. The AEC declined his application to enrol to vote for the 2014 special elections on the ground that the Commonwealth Electoral Act 1918 required a minimum age of 18 to vote. He filed an action in the High Court questioning the constitutionality of said law. He claimed that the law violates Section 7 and 24 of the Australian Constitution, which guarantees that members of Parliament shall be directly chosen by the people, rule on the validity of such law.
Okay.
Well, he's not an adult yet. And I don't know, maybe somebody in the audience can answer this. I was under the understanding that people under the age of 18 are not sent overseas to fight.
Yeah, I can vouch for that one, Erin. That's not the case at all. I know plenty of people that have not reached the age of 18 that have been overseas.
Yeah, I think I've got relatives that are under 18 in the army.
Okay, so let's just assume for the moment that a 17-year-old Australian citizen can join the Australian Defence Force. And so therefore, that person can be exposed to death, especially if that person goes to a war zone. And so the question is, would such a law be valid, which requires a minimum age of 18?
That's up to the Parliament to make that decision, isn't it?
So how would you answer that, Nicholas?
Well, it's up to the Parliament to make the decision as to what age we're allowed to vote by. They're given the authority to make that decision under the Constitution.
That's right. So under Section 30 of the Australian Constitution, the Commonwealth Parliament actually has the power to determine the qualifications of voters, including questions about age and mental fitness.
Yeah, and thus him trying to challenge a 17-year-old trying to challenge that in the High Court's going to go, this is not our issue. This is an issue of Parliament, and they have the judiciary has no standing in that, so they would just dismiss it outright.
Very good. And there is an important point here made by Kathleen Smith, that in McKinley, the majority High Court held that the Constitution does not guarantee universal adult suffrage or the voting rights of infants and minors, among others. So there is no universal adult suffrage in Australia. And a lot of it will be dependent on the exercise of the power by the Commonwealth Parliament in relation to who qualifies as voters.
Manja, that actually was an issue that was raised in the throes of the Vietnam War, wasn't it? And they actually did lower the age of voting from 21 to 18 because of that war.
That could be right, Rin, but I wasn't in Australia then. So I wouldn't be familiar, but you're probably correct. So what we need to remember actually in relation to this point is that there was a time when Aborigines and Australian women did not have the right to vote. And that particular right to vote is not even guaranteed in the Constitution, which brings us to the case of McKinley. So it was upon the exercise of Parliament's power under Section 30 that eventually Indigenous people and women were allowed to vote. And as pointed out by Erin here, during the Vietnam War, the right of suffrage was lowered from the age of 21 to 18. Thank you for that historical fact, Erin.
Wasn't there another case with people incarcerated where they wanted to change it so that nobody who was incarcerated for any period of time would be allowed to vote, and they actioned that, and then it was actually repealed and brought back to the previous act, which said only people who have 3 years or more.
That's right. So if you examine Roach versus Electoral Commission, the High Court, though, clarified that if the incarceration, for example, is for somebody, if somebody is incarcerated for a period of less than 3 years and that person then is disqualified from voting, then that would be violative of the principle of representative democracy under Section 77 and 24 of the Australian Constitution. But beyond that, the High Court was willing to recognize the validity or the constitutionality of the determination by the Australian Parliament as to the qualifications of voters. So there was a 3-year cutoff period. You might say that that seems to be quite arbitrary, but again, that brings into that question of to what extent the High Court will defer to the Parliament in relation to certain political questions, because that is an example of a political question. With a 3-year arbitrary period, it can be argued. So on the one hand, if the length of incarceration is less than 3 years, the High Court said that violates the the principle of representative democracy and would be unconstitutional for violating Section 7 and 24, which gives the people the right to directly choose their representatives in Parliament. But anything beyond 3 years would be considered to be constitutional and valid.
All right, Manjo. Good job, my friend. I think by reading all the stuff tonight, I think a lot more people are starting to grasp this, even if we haven't grasped the electoral stuff yet.
Yeah, but I'm getting confused with the discussion about election law. Honestly,
I think everybody understands why. It's a very specific area which is inadvertently attached to how the Constitution affects it.
I would certainly examine, but I'd like to point out: don't get too involved with the question about the details about election law, because it isn't really part of constitutional law. There are bigger questions in constitutional law that we'll be examining, particularly in relation to the powers of the lower house and the upper house, the tension between the states and the federal government, and the tension between the three branches of government, and constitutional rights and freedoms. Those are the focus of constitutional law, not about the specifics of election law, because that is covered by a different subject. I'm not even sure if we're teaching that.
Yeah, no. I think everybody's pretty clear on that. It's just that it's one of those areas, I guess, that does touch constitutional law pretty heavily, and so on occasion, being new students, these questions are going to arise, and it's nice. It's nice to have you there to pull us back on track, Manjo. It's all good.
Yeah, but it's very surprising to be asked those questions. Realize I don't know the answers to those. Okay, but as I said, I'm teaching constitutional law, not election law. Okay, so thank you for that. And I know that others have other classes. I've got a class at 7:15 as well. So thanks everyone for joining tonight's session. And if you have any questions, feel free to send me an email. Good night. Bye.